Public notice to all, filed in the records of Moorish American Consular Court Maryland Superior Court in Maryland Territory dated 2024 September 11/1446 Moorish calendar year affirmed on October 7, 2023 Moorish American Consular Court Maryland Territory Court Clerk by Byron Zahar Bey, Chief Clerk. Record number mac000000120. Filed 002 The Constitution for the United States Decapitalized Empire State of Morocco Byron Calvin Rodgers 2 of 42 Chief Justice Moorish Empire Maryland Territory Foundational document sent by All Moors for All Moors and Our Empire State of Morocco Foundational documents 2 of 42. Sovereign Original Indigenous American Moor, Byron Calvin Rodgers, Moorish American National, Marylander, Choctaw and Aniunwiya bloodline and living heir, House of David Yahuda. Having chosen appellation Byron Zahar Bey and Hebrew Israelite spiritual appellation Chief Baubau Zahar ben Yaira el. I am a living heir and ascendant of the great Pharaohs of Kemet, alive in full life within the ancient Moroccan Moorish Empire, having dominions that include all the territory of North America, South America, Central America, and the adjoining islands of the whole continental Americas. Empire State of Morocco, United States for America, Moorish National Republic Federal Government, Societas Republicae Almoricanos, Moorish Divine and National Movement of the Earth. Northwest Amaxim, Northwest Africa, North America, the North Gate, all adjoining islands, Turtle Island, Temple of the Moon and Sun, the true and de jure natural peoples, heirs of the land. Universal Sovereigne Original Indigenous Natural Divine Affidavit. Constitution for the United States of America 1442. Always and stand and remain standing into perpetuity. This is a sovereignty livingency and Article 3 Moorish American Moroccan constitutione. I am sovereignly living justice Byron Calvin Rodgers in capitis diminutio nolo, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes. My free chosen national appellation is Byron Zahar Bey in capitis diminutio nolo, in red ink, in propria persona sui juris, in proprio solo, and in proprio heredes. I and all Moors are the original indigenous sovereignians and Moroccan Moorish American ascendants of the great Pharaohs of Kemet and of the ancient Moabites and Canaanites. Our full faith and trust, our allegiance, our credit and our energy are hereby vested in ourselves, for we are the people who are the original indigenous natural divine and empire state of Morocco and the de jure Moorish National Republic Federal Government. We are one God. We hereby exercise all sovereignty rights at this time and at all points in time nunc pro tunc. Preamble. We the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Preamble. We the people of the United States, in order Section 1. Article I. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Section 2. The House of Representatives shall be composed of members chosen every second year by the people of the several states. And the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature. No person shall be a representative who shall not have attained to the age of 25 years, and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen. Representatives and direct taxes shall be apportioned among the several states which may be included within this union, according to their respective numbers. Which shall be determined by adding to the whole number of free persons, including those bounded to service for a term of years, and excluding Indians not taxed. 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years. In such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative, and until such enumeration shall be made. The state of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies. The House of Representatives shall choose their Speaker and their officers, and shall have the sole power of impeachment. Section 3. The Senate of the United States shall be composed of 2 senators from each state, for 6 years, and each senator shall have 1 vote. Immediately after they shall be assembled in consequence of the first election, they shall be divided as equally as may be into 3 classes. The seats of the senators of the first class shall be vacated at the expiration of the second year, of the second class at the expiration of the 4th year, and of the third class at the expiration of the 6th year, so that 1/3 may be chosen every second year. And if vacancies happen by resignation, or otherwise during the recess of the legislature of any state, the executive thereof may make temporary appointments until the next meeting of the legislature, which shall then fill such vacancies. No person shall be a senator who shall not have attained to the age of 30 years, and been 9 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state for which he shall be chosen. The Vice Presidente of the United States shall be Presidente of the Senate, but shall have no vote, unless they be equally divided. The Senate shall choose their officers, and also a Presidente pro tempore, in the absence of the Vice Presidente, or when he shall exercise the office of Presidente of the United States. The Senate shall have the sole power to try all impeachments. When sitting for that purpose, they shall be on oath or affirmation. When the Presidente of the United States is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the membres presente. Judgment in causes of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust or profit under the United States, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment and punishment, according to law. Section 4. The times, places and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. The Congress shall assemble at least once in every year, and such meeting shall be, unless they shall by law appoint a different day. Section 5. Each house shall be the judge of the elections. Returns and qualifications of its own members and a majority of each shall constitute a quorum to do business, but a smaller number may adjourn from day to day and may be authorized to compel the attendance of absent members in such manner, and under such penalties as each house may provide. Each house may determine the rules of its proceedings, punish its members for disorderly behavior, and why the concurrence of 2/3, expel a membre. Each house shall keep a journal of its proceedings and from time to time publish the same, excepting such parties as may in their judgment require secrecy. And the yeas and nays of the members of either house on any question shall, at the desire of 1/5 of those presente, be entered on the journal. Neither house, during the session of Congress, shall, without the consent of the other, adjourn for more than 3 days. Nor to any other place than that in which the two houses shall be sitting. Section 6. The senators and representatives shall receive a compensation for their services, to be ascertained by law, and paid out of the treasury of the United States. They shall in all cases, except treason, felony and breach of the peace, be privileged from arrest during their attendance at the session of their respective houses. And in going to and returning from the same and for any speech or debate in either house, they shall not be questioned in any other place. No senator or representative shall, during the time for which he was elected, be appointed to any civil office under the authority of the United States, which shall have been created, or the emoluments whereof shall have been increased during such time, and no person holding any office under the United States shall be a member of either house during his continuance in office. Section 7. All bills for raising revenue shall originate in the House of Representatives, but the Senate may propose or concur with amendments as on other bills. Every bill which shall have passed the House of Representatives and the Senate, shall, before it become a law, be presented to the Presidente of the United States. If he approve, he shall sign it, but if not, he shall return it with his objections to that house in which it shall have originated, who shall enter the objections at large on their journal, and proceed to reconsider it. If after such reconsideration 2/3 of that house shall agree to pass the bill, it shall be sent, together with the objections, to the other house, by which it shall likewise be reconsidered, and if approved by 2/3 of that house, it shall become a law. But in all such causes the votes of both houses shall be determined by yeas and nays. And the names of the persons voting for and against the bill shall be entered on the journal of each house respectively. If any bill shall not be returned by the Presidente within 10 days after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. Every order, resolution, or vote to which the concurrence of the Senate and House of Representatives may be necessary shall be presented to the Presidente of the United States, and before the same shall take effect, shall be approved by him, or being disapproved by him, shall be repassed by 2/3 of the Senate and House of Representatives, according to the rules and limitations prescribed in the cause of a bill. Section 8. The United States Congress shall have power to lay and collect taxes, duties, imposts and excesses, to paye the debts and provide for the common defense and general welfare of the United States, but all duties, imposts and excesses shall be uniform throughout the United States. To borrow money on the credit of the United States, to regulate commerce with foreign nations, and among the several states, and with the Indian tribes. To establish an uniform rule of naturalization, and uniform laws on the subject of bankruptcies throughout the United States. To coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. To provide for the punishment of counterfeiting the securities and current coin of the United States, to establish post offices and post roads. To promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. To constitute tribunals inferior to the Supreme Court, to define and punish heresies and felonies commit on the high seas, and offences against the law of nations. To declare war, grant letters of marque to and reprisal, and make rules concerning captures on land and water. To raise and support arms, but no appropriation of money to that usually be for a longer term than 2 years, to provide and maintain a navy. To make rules for the government and regulation of the land and naval forces. To provide for calling for the militia to execute the laws of the unions, suppress insurrections and repel invasions. To provide for organizing, arming, and disciplining, the militia, and for governing such part of them as may be employed in the service of the United States. Reserving to the states respectively, the appointment of the officers, and the authority of training the militia according to the discipline prescribed by Congress. To exercise exclusive legislation in all cases whatsoever, over such district as may, by cessione of particular states, and the acceptance of Congress, become the seat of the government of the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be. For the erection of fortes, magazines, arsenals, dockyards and other needful buildings, and to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. And all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Section 9. Clause 1. The migration or importation of such persons as any of the states now existing shall think proper to emit, shall not be prohibited by the Congress prior to the year 2020 and 2, but a tax or duty may be imposed on such importation, not exceeding $10 for each person. Clause 2. The privilege of the writ of habeas corpus shall not be suspended, unless when in causes of rebellion or invasion the public safety may require it. Clause 3. No bill of ad inde or ex post facto law shall be passed. Clause 4. No capitation, or other direct tax shall be laid, unless in proportion to the census or enumeration herein before directed to be taken. Clause 5. No tax or duty shall be laid on articles exported from any state. Clause 6. No preference shall be given by any regulation of commerce or revenue to the ports of one state over those of another, nor shall vessels bounded to or from one state be obliged to enter, clear, or paye duties in another. Clause 7. No money shall be drawn from the treasury, but in consequence of appropriations made by law and a regular statement and account of the receipts and expenditures of all public money shall be published from time to time. Clause 8. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, except of any presente, emolument, office, or title, of any kind whatever from any king, prince, or foreign state. Section 10. Clause 1. No state shall enter into any treaty, alliance, or confederation, grant letters of marque to and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, passe any bill of ad inde, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Clause 2. No state shall, without the consent of the Congress, lay any imposts or duties on imports or exports. except what may be absolutely necessary for executing the inspection laws of said state. And the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the treasury of the United States. And all such laws shall be subject to the revision and control of the Congress. Clause 3. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state, or with the foreign power, or and engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. Section 1. Article 2. The executive power shall be vested in a Presidente of the United States of America. He shall hold his office during the term of 4 years and together with the Vice Presidente chosen for the same term, be elected, as follows. Each state shall appoint, in such manner as the legislature thereof may direct, a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress. But no senator or representative or person holding an office of trust or profit under the United States, shall be appointed an elector. The electors shall meet in their respective states, and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for, and of the number of votes for each. Which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the Presidente of the Senate. The Presidente of the Senate shall, in the presence of the Senate and House of Representatives, append all the certificates, and the votes shall then be counted. The person having the greatest number of votes shall be the Presidente, if such number be a majority of the whole number of electors appointed. And if there be more than one who have such majority, and have an equal number of votes, then the House of Representatives shall immediately choose by ballot one of them for Presidente. And if no person have a majority, then from the 5 highest on the list, the said House shall in like manner choose the Presidente. But in choosing the Presidente, the votes shall be taken by states, the representation from each state having 1 vote. A quorum for this purpose shall consist of a membre or membres from 2/3 of the states, and a majority of all the states shall be necessary to a choice. In every case, after the choice of the Presidente, the person having the greatest number of votes of the electors shall be the Vice Presidente. But if there should remain 2 or more who have equal votes, the Senate shall choose from them by ballot the Vice Presidente. The Congress may determine the time of choosing the electors, and the day on which they shall give their votes, which day shall be the same throughout the United States. No person except a natural-born national, or a national of the United States, at the time of the adoption of this Constitution, shall be eligible to the office of Presidente. Neither shall any person be eligible to that office who shall not have attained to the age of 35 years, and been 14 years domiciled within the sovereign United States. In cause of the removal of the Presidente from office, or of his death, resignation, or inability to discharge the powers and duties of the said office, the same shall devolve on the Vice Presidente, and the Congress may by law provide for the cause of removal, death, resignation, or inability, vote of the Presidente and Vice Presidente, declaring what officer shall then be as Presidente, and such officer shall commence accordingly, until the disability be removed, or a Presidente shall be elected. The Presidente shall, at stated times, receive for his services, a compensation, which shall neither be increased nor diminished during the period for which he shall have been elected. And he shall not receive within that period any other emolument from the United States, or any of them. Before he enter on the execution of his office, he shall take the following affirmation. I do solemnly affirm that I will faithfully execute the office of Presidente of the United States, and will in the spirit of love, truth, peace, freedom, and justice, preserve, protect, enforce and defend the Constitution for the United States. Section 2. The Presidente shall be Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. When called into the actual service of the United States, he may require the opinion, in writing, of the principal officer in each of the executive ministries, upon any subject relating to the duties of each their respective offices, and he shall have power to grant reprieves and pardons for offences against the United States, except in causes of impeachment. He shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur. And he shall nominate, and by and with the advice and consent of the Senate, shall appoint ambassadors, either public ministers and consuls, judges of the Supreme Court, and all either officers of the United States, whose appointments are not herein otherwise provided for, and which shall be established by law. But the Congress may by law vest the appointment of such inferior officers, as they think proper, in the Presidente alone, in the courts of law, or in the heads of ministries. The Presidente shall have power to fill up all vacancies that may happen during the recess of the Senate, by granting commissions which shall expire at the end of their next sessione. Section 3. He shall from time to time give to the Congress information of the state of the Union, and recommend to their consideration such measures as he shall judge necessary and expedient. He may, on extraordinary occasions, convene both houses, or either of them, and in cause of disagreement between them, with respect to the time of adjournment. He may adjourn them to such time as he shall think proper. He shall receive ambassadors and other public ministers. He shall take care that the laws be faithfully executed, and shall commission all the officers of the United States. Section 4. The Presidente, Vice Presidente and all civil officers of the United States, shall be removed from office on impeachment for, and conviction of treason, bribery or other high crimes and misdemeanors. Article 3. Section 1. The judicial power of the United States, shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times, receive for their services, a compensation, which shall not be diminished during their continuance in office. Section 2. The judicial power shall extend to all causes, in law and activity, arising under this Constitution, the laws of the United States, and treaties made, or which shall be made. Under their authority, to all causes affecting ambassadors, either public ministers and consuls. Plus to all causes of admiralty and maritime jurisdiction. Plus to controversies to which the United States shall be a party. Plus to controversies between two or more states. Plus between a state and citizens of another state. Plus between citizens of different states. Plus between citizens of the same state claiming lands under grantees of different states. In all causes affecting ambassadors, either public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other causes before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions, and under such regulations as the Congress shall make. The trial of all crimes, except in causes of impeachment shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. J. Section 3. Treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act, or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work a corruption of blood, or forfeiture except during the life of the person attainted. Section 1. Article Life. Full faith and credit shall be given in each state to the public acts, heredes, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, heredes and proceedings shall be proved, and the effect thereof. Section 2. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice, and be found in another state, shall on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service or labour in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labour, but shall be delivered up on claim of the party to whom such service or labour may be due. Section 3. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states, or parties of states, without the consent of the legislatures of the states concerned as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States, or of any particular state. Section 4. The United States shall guarantee to every state in this Union a republican form of government, and shall protect each of them against invasion, and on application of the legislature, or of the executive against domestic violence. Article V. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or, on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either cause shall be valid to all intents and purposes, as part of this Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventiones in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. Provided that no amendment which may be made pre or to the year 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without the consent of said state, shall be deprived of its actual suffrage in the Senate. Article 6. All debts contract and engagements entered into, before the adoption of this Constitution, shall be as valid against the United States under this Constitution as under the Confederation. This Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the membres of the several state legislatures, and all executive and judicial officers. Both of the United States and of the several states, shall be bound by affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust under the United States. Article 7. The ratification of the conventions of 9 states, shall be sufficient for the establishment of this Constitution between the states so ratifying the same. Done in convention by the unanimous consent of the states present the 17th day of September in the year of our Lord 1787 and of the independence of the United States of America, the first saint, in witness whereof our sovereigne appellations are hereby autographed. All sovereigne original indigenous ancient divine Moorish American autographs affirming this, and all sovereigne original indigenous ancient empire state ob Morocco and the de jure. Moorish National Republic Federal Government documents are on the public record at America, ancient Morocco, Northwest Amaxim, Northwest Africa, the North Gate, Turtle Island, Gaia, Midgardi, Earth. Chronos time immemorial into perpetuity. Ego sum. Byron Calvin Rodgers Justice Vizier Mini Star. In capitis diminutio nolo, in red ink, in propria persona sui juris in proprio solo in proprio heredes. No ties to agent is no ties to principle. No ties to principle is no ties to agent. Empire State of Morocco. Moorish National Republic Federal Government. Moorish American Consulate.